This meeting of the local review body of the 11th of April 2024. I can confirm that the meeting has been properly called and is quorate. Can I first ask members to appoint a chair for this meeting, please?
I'd like to propose Councillor Andy McFarlane chair this meeting. Thank you.
Okay, Councillor McFarlane, are you happy to accept that?
I would prefer not to.
Do we have anybody willing to put themselves forward as chair?
Can I nominate Councillor Thompson, but in his absence I will do it.
Councillor Thompson isn't actually on the Saturant for this meeting. I can see he's in the meeting, but he's not actually on the membership.
Yeah, okay, Claire, I'll do that then, no problem.
It's fine, Claire, I'm here. Sorry, I must have missed just the very start of the meeting, so apologies for that.
Okay, Councillor McFarlane, are you happy to chair? Councillor Thompson, you're not on this local review body.
Oh, I beg your pardon. Sorry, my mistake.
Yeah, no problem, Claire. That's one I will make, Councillor Dempster. Okay, so how do we proceed from here then, Claire?
Okay, just checking then, Councillor McFarlane, have you got a copy of the chair's notes that were distributed in advance of the meeting?
I don't have them to hand, so let me see if I can find them.
Well, can I suggest we have a short adjournment per minute or so just to get those to you? Thank you.
Okay.
Yeah, good to go.
Yeah, good morning everybody. Welcome to this meeting of the local review body of the 11th of April 2024. I can confirm that the meeting has been properly called and is quorate. I would first ask members to appoint a chair for this meeting. That's what you've done, Claire, so I've been appointed. So good morning members, welcome to meeting the local review body. This meeting has been live streamed and recorded, and the recording will be made available on the council website for public listening. Remote participants, which is all of us, please follow a good practice guide, which includes muting microphones and switching off your video when you're not addressing the meeting. Writing speak in the Teams chat function when you want to contribute, or alternately stick your hand up. No material should be posted in the chat function if it is intended as part of a discussion. The usual standing orders apply, including that any votes will be undertaken by roll call. All members should speak clearly and directly into the microphone when making contributions, and when referring to reports, please provide the reference to the relevant page and paragraph to allow everyone to follow. Claire, can you give me the Siderant and apologies, please?
Okay, thank you, Chair. We have 6 members present today, all attending via Teams. One apology today from Councillor Drysdale.
Thank you. Do members have any declarations of interest in relation to today's work? Okay, I'll take that as a no. Claire, can you take us through the documents and papers for today's meeting, please?
Okay, thank you, Chair. I can confirm we've got 3 notices of review for today's meeting. The first being item 4, land to south east of Carslewis Bridge, Carslewis, Newton Stewart, non-determination of application within the statutory time period for planning permission in principle for proposed residential development, 4 dwelling houses. That's 232077 PIP. The usual papers in your papers for the meeting. You've got the notice of review, consultation, responses and correspondence, observations of appointed officer on the applicant's agent's notice of review, observations of applicant's agent on observations of the appointed officer, planning application form submitted on the 28th of September 2023, relevant extracts from the Dumfries and Galway Local Development Plan 2 and National Planning Framework 4, and the photos of the application site and locality. Requested method of determination. The applicant has asked that the review be dealt with by means of further written submissions on specific matters, that the appellant be afforded the right to respond to any matters raised by Council in its comments, or if there are particular matters raised regarding the proposal that the appellant has not been made aware of to date by the case officer. Members should note that the applicant's agent has already responded in writing to the observations of the appointed officer, and these appear on pages 79 to 80. Grounds stated in notice of review are, in summary, the proposal accords with LDP 2 policy H2 and its supplementary guidance note regarding housing development in villages. It proposes a form and units of a number of units that reflects those already in the village with a careful design. Any dwellings will complement those dwellings in the village. The dwellings can easily be accessed and serviced and would be a pattern of development shown as being acceptable in LDP2 adopted supplementary guidance note regarding housing in villages. It is contended that this development proposes an appropriate number of units that relates well to the scale, size and pattern of other residential properties within the existing village. With careful and considered design, any dwellings constructed on the plots proposed would comply with provisions of the design quality of new development LDP2 supplementary guidance note. The development will incorporate and encourage measures that are likely to facilitate home working. Satisfactory access and services are readily available and capable of being provided by the developers of the plots. If the relevant development plan policies in your papers, being for LDP2, you've got OP1, OP2, OP3, ED10, H2, H3, HE1, NE2, IN8 and IN9 and T2, supplementary guidance, housing development in villages, design quality and placemaking, housing in the countryside, and sustainability, reducing carbon emissions in buildings, and dark sky friendly lighting. For MPF 4, you have policies 1, 2, 3, 4, 12, 14, 16, 17, 18, 22, 29 and 30. The main issues for the local review body to consider are: does the proposal fail to comply in principle with the terms of the development plan? In particular, does the proposal fail to accord with LDP2 policy H2 housing development in village and associated LDP2 supplementary guidance entitled housing development in villages? Does the proposal accord in principle with the terms of MPF4 policy 17 on rural homes? Does the proposal fail to comply in principle with LDP2 policy H3 housing in the countryside and associated LDP2 supplementary guidance entitled housing in the countryside? More specifically, has it been demonstrated that the location and scale of the proposed development accords with the development plan provisions? Would the application site read as being part of the village? Would the proposed development represent urban development, and if so, would this be considered unacceptable? If it is not considered that the proposal accords with the terms of the development plan, are there a set of material considerations of sufficient weight to justify a departure from the terms of the development plan? If so, on what grounds would the decision be made, and what reasons would members give for such a decision if it was considered that the proposal departs from the terms of the development plan? If members are minded to reverse the appointed officer's decision and instead grant planning permission for this proposal, what set of conditions and reasons would members wish to see attached, if any? and members are instead minded to vary the terms of the appointed officer's decision and make reference to the relevant determining development policies beyond those stated within the delegated report and decision notice. What changes to the specific reasoning for the decision would be required, and which additional policies, if any, would be referenced. So, having outlined the documents within the papers, it now falls to the LRB to determine whether it has sufficient information to consider the review. It is confirmed that no representations from any party will be heard today. The options available for this review and the two that follow are: does the LRB can decide it has sufficient information before it to determine the review today, request further information in the form of written representations. The LRB would be required to state precisely the information it was seeking and who must provide it, resolve to hold a hearing, again specifying who would be invited to speak and on what matters, resolve to hold a site visit, accompanied or unaccompanied, as can be done in conjunction with any of the above, but would obviously not allow a decision to be made today. And if the local review body resolves it has sufficient information and that no further procedure is required, then the local review body has the full powers to uphold, reverse or vary a determination. The decision notice would include a statement of the terms in which the planning authority has decided the case reviewed. You have a planning advisor present at your meeting in relation to this case. It's confirmed that he has not had any involvement in this case prior to submission of the notice review. He was not the case officer or the appointed officer for this application. He's purely to provide independent advice as needed on matters of planning policy, law or process to the local review body. And you also have a solicitor present here today, and she will act independently if the local review body require any specific advice on matters of law. So members are clear, no further clarification is required. I will ask the chair now to lead the debate, and in the first instance to lead the local review body through the agenda papers together to decide if you have sufficient information before you to make a determination today.
Thanks, Claire. Okay, members, making the assumption, as I should, that you've all gone through the papers. Do we have sufficient information, or do you think we have sufficient information within the papers today to make this decision? It comes before us as it's been submitted to us because we failed to comply with the 2-month timescale, and it has been deemed as a refusal. So do members have any views, thoughts, concerns? Councillor Howie.
Happy to proceed with the information we have today, Chair.
Okay, thank you. Claire, you say we have a planning officer here?
Yes, Mr. Duncan's here.
Yeah, can Mr. Duncan perhaps run us through this application and perhaps highlight why we've failed to comply with the 2-month timescale, please?
Okay, thanks, Chair. I'm here today in front of you as independent planning advisor, so I'm here to really answer any questions or queries you've got. It's an application that was submitted for consideration to the council, and as you pointed out, it comes in front of you today because it wasn't determined within the statutory timescale. Now, when that happens, any applicant has a 3-month window to take what would be a delegated case to the council's local review body. So it's entirely legitimate that they've done that, and that's why it's here in front of you today. What you're looking at, I think what's important here is that you consider the submission as it's been made by the applicant and supported by the applicant's agent. So there's an original supporting statement which appears on pages 96 to 111 of your papers. You also have the observations of the applicant's agent to the appointed officers on pages 79 to 80. So he's basically setting out a case where he feels that permission in principle should be granted. It's an application for planning permission in principle. And he set out a case whereby it feels it should be granted by the local review body subject to conditions. The other information you have to make sense of the proposal is you have the application form as part of the submission. Now, I think that appears on page 89 of the papers. Bear with me while I just check that I've got the correct reference. It's actually earlier than that. So the submission you've got in front of you appears on page 83. So you've got the application form there. It's an application for planning permission in principle for residential development on this site, notionally for 4 residential units. So looking at that, you have that in front of you. On page 91, you have the location plan. This is a drawing to a scale of 1 to 2,500. So you can see the application site outlined in red, and you can see how that relates to the A75 public road, which is just to the kind of southwest of the application site. Then if you know Carsluth, there is the junction that turns off into the settlement, which is just to the east of this location. So that the high street that's marked, the U279W High Street, is on the other side of the site. So the site lies in between the A75 and that road in Carsluth. The other thing to note from the location plan is the watercourse and the bridge, which are located just to the kind of northwest of the end of the application site. You've got a more detailed plan that's been submitted on page 93. So this is the same application site outlined in red, but notionally it's showing an indicative layout for 4 separate housing units to indicate what they're thinking of developing at this site. Like I say, there is a statement there which was part of the original application, pages 96 to pages 111, and there is also the response in relation to the appointed officer comments, and that appears later within the document, or is it earlier? It's earlier actually. It's pages 79 to 80. So those are the key parts of the applicant's case. When it comes to the application itself and the case officer assessment, obviously there wasn't a determination made before it came in front of you today. So if you look at the appointed officer comments, which are on pages 79 to, sorry, bear with me, that's the wrong one. The observations of the appointed officer are somewhere different.
74, 75, I think.
74, 75, thanks, totally lost my place there. It's in the format of a report. So, local review body. So part 1 is in effect tantamount to a report that wasn't done before the case came in. And you can see that goes through the usual considerations and it arrives at a recommended decision for you, which is to refuse the application on the 2 grounds stated in pages 74 and 75. You've then got part 2 to the appointed officer comments, which appears on page 76. And that is just really summarising the overall position and the appointed officer's response to the reasons for seeking review. So that's the information you've got in front of you. Those are the key documents. You've got the views of the appointed officer and you've got the views of the applicant's agent, and it's really now for you to determine the case. I am happy as usual to go through the pictures if that would help, and the pictures are the same as those that appear in your papers at 151 to 154. So I can go through if you're okay with that, I can go through the presentation just now and then answer any questions that arise.
Yeah, thanks, Robert. That'd be helpful, I believe.
Okay, this is the first view, and as is standard, these slides have been provided by the case officer. I haven't been out and visited the site directly, but I do have some background knowledge of it. So this is a view. It's from the public road, the kind of high street that's shown on the site plan on page 93. This is looking to the northwest. So this is the bridge going over the watercourse that's mentioned. The next slide is in the opposite direction. So this is looking to the southeast, and this eventually joins to the A75 with a junction, but that's out of shot. So the application site, for the avoidance of doubt, is on the right-hand side here, behind the hedge and the trees. This is a view moving about 90 degrees. This is looking almost due southwest. It's looking into the actual application site, which you can see is a field at the moment, and this is from the edge of the public road. As a reference point, you can see the more elevated ground opposite with the shrubs on it. The A75 lies in between that area of land and the hedge that you see in the distance here. It's almost in a kind of cutting at that point. This is a view from within the application site. It's looking towards the northeast and the rising land behind Carsluth itself, where you've got the kind of bare trees there. You can see there's been some previous agricultural development sheds and such like within this area. And this is a view looking towards the southeast, again within the application site. So there is some kind of old, I don't know how you describe it, agricultural related stuff in this location. Then you've got a view within the site. This is similar to the image 3 back, and this is looking almost directly southwest again. This is a view again, it's within the application site and it's looking southeast. And another one looking southwest. And that concludes the pictures. So I hope that's helpful, Chair, but again, I'm happy to answer any questions that arise.
Yeah, thank you, Robert. Do members have any questions? Keith Walters, Councillor Walters.
Yeah, I just had a couple of things. I'm not sure if Robert's going to be able to answer these, but the main issues seem to be: is the site part of the village, as in does it link together with the village, and is it suitably scaled? I couldn't see anything that said how many houses there were in Carsluth to say, is this suitably scaled? I'm presuming that 4 extra houses in a village of however many houses there are in Carsluth, but that didn't. I couldn't really see whether that was the case. And the other issue seemed to be about this thing about the entrances, which was whether having one entrance off the main road was going to make it different than if all the proposed houses had different references. Those are my 3 questions, but like I say, I'm not sure if that's something that Mr. Duncan will be able to answer.
Robert?
Quite happy to answer that, Chair. The key thing is, when I look at all of the documents that are in front of you today, the key thing is clearly the policy on housing in the countryside here in relation to it being a housing site in a village. So there's 2 parts of the determination. You've got LDP2 policy H2, housing development in villages, and you've also got LDP2 policy H3, which is housing in the countryside. In this case, the test falls against policy H2. One of the key things which the applicant has submitted is the supplementary guidance, the LDP2 supplementary guidance on housing development in villages. That dates from February 2020. Now that's on your pages within pages 23 to 35 of your papers. The guidance on suitable sites in villages is provided in that document on page 25 of your papers at 1.3. So it does go on to describe things further, but at paragraph 1.3 it says new development should seek to reinforce the building pattern of the existing settlement and ensure that new buildings respect and contribute to the area's architectural and cultural heritage. Buildings in rural villages can often be seen over long distances, and therefore careful design is essential. And it carries on to look at various things, and it says the aim should be to develop high quality modern designs which maintain a sense of place and support local identity. Development which does not undermine the identity of rural areas should be supported. Making development welcoming is also important, especially in the layout of new houses on the edge of settlements and at the gateways or entrances to villages. And it then mentions about new development making use of spare capacity and existing infrastructure. So that's really a key document for determination, the LDP2 supplementary guidance. When you look at Carsluth itself, it's clearly a village, because when you look at the appendix to that document, Appendix 1 on page 34, in the Mid-Galloway housing market area, Carsluth is listed as a settlement. I did try and look up how big it was before the meeting, because I thought the question of size would come up. I would estimate that Carsluth is somewhere between 50 and 100 inhabitants in size, but that's my best guess. You've got a kind of element of it, a cluster of development near the smokehouse, which is more to the kind of northwest, and then you've got the kind of cluster around the more original part of the building, which is where the original part of the settlement, which is where this site is located closer to. But for me, it's clearly got to be assessed in terms of the policy on housing development in villages, because it's clear that Carsluth is a village. I don't know if that helps, but again, I'm happy to answer any more questions if I didn't answer that properly.
Thanks, Robert. Keith, are you satisfied with that?
Yeah, no, that's pretty helpful. Just going back to the LDP2 supplementary advice, has that not been sort of subsumed since then by the various MPF for the different housing, the rural housing policy and the policy 29, I think, which is what the agent mentions. Are we not supposed to be judging them against that rather than the LDP2 documents?
Thanks, Chair. It's a good question. MPF 4 has come in and it became part of the development plan back in February last year. You do have, looking at your papers on pages 130 to 131, you do have the policy on rural homes, and that does provide some guidance on that. So what you're looking at there is on page 131, it's saying development proposals for new homes in rural areas will be supported where the development is suitably scaled, sited and designed to be in keeping with the character of the area. And then it mentions things about the development as well. So what you're looking at is then whether or not the proposal is in conflict with MPF 4 policy 17. You've also got MPF 4 policy 16, quality homes, but I don't feel that those policies conflict with what you've got in LDP2, and the detail you've got in policy H2 by virtue of the supplementary guidance published as part of LDP2 gives you much greater detail, if you like, to go on when considering cases like this. So yes, MPF 417, policy 17 is relevant, but I don't think it's a game-changing document. I think it kind of supports LDP more than anything, and I don't feel it conflicts with what LDP2 is saying in respect of either the policy or the supplementary guidance.
Thank you, Robert. Councillor Marshall?
Thanks, Chair. Yeah, my question, Robert, is just with regards to what would be viewed as the settlement boundary to this part of this side of the village. I was looking at the plan on page 93, and obviously there's the Bridge Cottage, which is, the next one up from, and then there's the old schoolhouse and the Cree Lodge, and I'm just wondering whether or not, I think within the papers it suggests that the planning kind of assess the stream as being a natural boundary, whereas I've seen in other villages and small settlements the fact that the old schoolhouse is there. I'm just wondering, is the old schoolhouse, is it used as is it like a private dwelling now, or is it like a community centre? Because I can remember a number of years ago, probably an example just near my ward was Rigg, where you had Mansfield Hall, but you did have houses on the other side of Mansfield Hall, on the other side of the road, that were right up to where Mansfield Hall, but there was a gap site between on the other opposite side of the road, which we gave permission for 4 bungalows. So I'm just wondering whether or not the old schoolhouse could be classed as a natural boundary, albeit that there's no development on either side apart from Bridge Cottage.
Robert?
Thanks, Chair. In the appointed officer comments, this is an issue that's looked at primarily at paragraphs 4.9, 4.10 and 4.11. So you're at pages 73 and 74 in your papers, and it looks at, paragraph 4.9 looks at the issue of boundaries of villages, and it says an assessment must be made on a case-by-case basis, as LDP2 does not provide inset maps or define settlement boundaries. Then the case officer makes their argument as to why they think this is not located within the village boundary. So you're taking an interpretation on a case-by-case basis. On the other hand, you've obviously seen the comments from the applicant's agent, and they are making a case that, well, this should be considered to be within the settlement boundary, and the kind of use of, if you like, the water course to the west and the bridge as defining the settlement boundary is a red herring. And part of the justification for that is the presence of the schoolhouse and the other building to the east of that location. So you've got the appointed officer saying, no, this isn't within the village, it fails to comply with the policy, and you've got the applicant's agent actually advocating an argument that says this is within the settlement boundary and you should grant it permission. So it's entirely a matter of interpretation. There isn't a hard and fast rule or definition of the settlement boundary here. You have to go by the criteria in the policy. But yeah, I mean, that's the crux of the argument you're looking at today. Is this within the settlement boundary? Is it not? Does it relate well to the existing village and scale, location, and kind of layout as well? So primarily, it's the principle of housing development at this site. Does it meet the housing development and villages policy and guidance?
Thank you, Robert.
Thank you. Councillor Howie, Ian.
Thanks. Just following on from Sean's points there, where you see the old schoolhouse, probably just within about 30 yards of that, you have the junction with the A75, the east side junction of Gusluth Village is right at that location, and that might be a more suitable defined boundary. The junction with the U279 with the A75, that's quite clear, as opposed to the burn where there's already houses to the east of the burn. So a clearer defined boundary may well be the junction with the A75.
Thank you, Ian. My views on it, looking at the map on page 91, is the predomination of properties are to the north of U279W and to the west of the burn. The Carsluth Mill is up to the north, but really it's up to members to make a decision as to whether they feel that this is within the boundary or not. Give any considerations to any possible vehicle movements that could possibly be a busy road that going on and off the 75. Really for members to have a view on that. Do you have any comments or? Councillor Howie?
Chair, can we just have a bit of clarity on junctions from the proposed site onto the A75? My understanding was all vehicle access would come off at the High Street.
Yeah, Robert, can you clarify that?
That's correct, Chair. Your best reference is probably the indicative layout drawing on page 93. So you're looking at a shared access for indicatively 4 detached residential units. So yes, the proposed access would come off the U279W.
Yeah, just for clarification, Robert, would that be the U279W? There is access to and from the 75 from this end, isn't there?
Yes, it's not shown in any of the plans, but as has been discussed, if you go further to the southeast, there is a junction there from that road onto the A75 directly.
Okay, thank you. Councillor Dempster. Jim?
Thanks, Chair. It was just a suggestion that Claire did put in the chat function very early that there are a number of sections listed in the papers, and maybe she go through every section, because it looks like we're drifting towards some kind of conclusion, and it might be useful if we just did a procedural thing, checked each section, and then you can maybe summarise before we go forward, if that's helpful, Councillor McFarlane.
Yeah, thank you, Jim, but this is what happens when you get an inexperienced chair, so thank you for your nomination. Okay, if we would want to pick up on Councillor Dempster's suggestion. Notice of review, everyone will have read through that. I had one particular issue in relation to the review procedure. It said no local review body decides procedures. Can this review continue by a conclusion in your opinion? And it's been marked no. Is that an error? No. It's on page 20, sorry.
Yeah, thanks, Chair. No, I did look at this twice, and what it says on the form, page 20, It says no, as you've pointed out, and it says that the further procedure is further written submissions on specific matters. Now, the applicant's agent has been able to do that by virtue of having a response to the appointed officer's comments. But further below, there's a box below that, and it says, as this is an appeal against non-determination, it is in the interest of natural justice that the appellant be afforded the right to respond to any matters raised by the council in its comments, or if there are particular matters raised regarding the proposal that the appellant has not been made aware of to date by the case officer. Now, I read that as having the right of response to any appointed officer comments, because there wasn't a case report at that point in time, and they've been able to do that. There has been a response from the agent to the appointed officer's comments, which took the form of a report. So I'm quite happy that they've had the right to make the further written submissions they were looking for.
Thank you. Thank you. Moving on to Housing Development Villages, that's there for guidance. Consultation, responses and correspondence. Just relates to perhaps one of the later ones as well as this one, Robert. Do we have a rationale as to why we get the most recent email before we get the first? Because you happen to go to the end of the papers to find it. And it happens regularly where, it's done chronologically in reverse.
Thanks, Chair. It's just the way the documents are assembled, where it's a delegated report and related documentation. They tend to be assembled with the most recent thing first. So the delegated report is the culmination of everything that goes from it forward into the papers, but it is in reverse order, as you point out. So basically, you've got the completed delegated report. It normally would be the case there, and then you've got the constituent parts of that or the correspondence relating to it, but it is all in reverse date order.
Okay, so it's obviously how we just do it. Okay, thank you. Consultation responses. Members get any comments or questions? Okay. Household and local pre-application equality. Starting on page 58. The pre-inquiry report. Any questions or comments by members? Okay. Observations of the appointed officer and applicant's agent, notice of review from page 69. See, there's no objections from Transport Scotland, Council Roads Officer or Scottish Water. On page 70, planning constraints affected by the site include Galloway Hills Regional Scenic Area, road fronting the site forms part of Core Path, Galloway Southern Ayrshire Biosphere Reserve and Dark Sky Park. Members get any comments or questions? Okay. Conclusion, obviously Robert's drawn our attention to that previously, page 74 and 75. It seems to focus around the fact that it doesn't accord with H2 and H3, NFP4. No other material considerations of sufficient weight to indicate otherwise. Consequently, recommendation is application should be refused for the following reasons. Comments, questions? No. Observations of the applicant's agent, starting on page 79. On page 80, one comment on the 1, 2, 3, 4, fourth paragraph, proposal seeks a single point of access to all 4 properties. On page 83, residential development parcel of grazing land opposite a bridge within the village of Carfluth. But that's obviously the architect is saying that. Okay. Sorry, Keith. Sorry, didn't see your hand there.
Sorry, yeah, just that point that you brought up on page 80, which is the single point of access from the public road. The agent seems to be using that as the argument that it's not ribbon development. It's not ribbon development because it's And when you look at the map, it appears to be directly opposite Bridge Cottage. Presumably that's why the access is there, so that it actually would be part of the village. If you look at it on page 93, I suppose the one access that they're proposing is directly opposite the cottage, which their argument the argument is that is part of the settlement, and that's why it would be seen as part of the settlement.
Okay, thanks, Keith. I mean, for me, I think the officer's trying to make the case that it's not part of the village. Therefore, I don't know if that would constitute a ribbon development. Robert, do you able to sort of make a comment on that?
The ribbon development notion is one that's developed within the report, and you'll also find it in the LDP2 supplementary guidance on housing development in villages. That document does explain what ribbon development is, and again, you need to take an interpretation as to whether it is ribbon development or not, and if so, if that is damaging to the kind of scale and pattern of the location or not. You've also got the whole issue, as we've discussed previously, of, you know, do you interpret this site as being part of the village or not part of the village as well?
Yeah, thank you. I mean, my understanding and interpretation of ribbon development would be whereby it starts to join up between hamlets or that sort of thing, but where it can be seen to be extending. Whereas obviously in this case, with the 75 being there, it would be unlikely that would be extended further. But really, it's a case for members to have a look at. Okay, moving on. Plan application submitted on 25th. It is what it is, I think. And then we're into LDPs and MPFs. Okay, members, so are we in a position whereby we can take a view on this? Anyone out there? Yeah, Keith?
I think I'd be happy to take a view on it. I'm not sure. I suppose my view is I'm thinking I disagree with the officer that it's not within the settlement. So if I was saying that yes, I would agree that it's within the settlement, I don't see why there is a reason not to pass it. How we'd actually justify that. I don't know, by reference to one of the MPF policies, like policy on 29 on rural development. But yeah, that's the way I'm looking at the moment.
Okay, are you putting that forward as a proposal, Keith?
Yeah, I'm happy to put that forward as a proposal, yeah.
No, so just for clarification, happy to put forward as a proposal that we take the officer's decision to refuse.
Sorry, I missed a bit.
That we accept the officer's decision and refuse. Is that your proposal?
No, actually, no. I would be going the other way, which is that
okay.
That because of MPF policy 29 on rural development, which is quoted in here, and the disagreement about whether it is part of the settlement. If it is part of the settlement, there doesn't seem any reason not to go ahead.
Okay, thank you for that. Councillor Dempster, Jim?
Thanks, Chair. I have the opposite view. Looking at page 93, I think it's quite clear that it constitutes ribbon development, and I would propose that we accept the recommended decision on page 74 and 75 and go with that as a decision for the LRB to make today. Thank you, Chair.
Okay, thank you for that, Jim. Okay, so we've got one member saying that we should go with the officer's recommendation, and one saying we should go contrary to the officer's recommendation. Do we have anyone else to support that, either position? Okay. I'm minded to follow Councillor Dempster in this case. Believe that the officer's done all due diligence, and that would be my proposal to support Councillor Dempster. Councillor Davis, Lynn?
Yes, I'm same as Councillor Dempster and yourself, Chair. I would be happy to second or third that decision. Thanks.
Okay, thank you for that. Do we have a seconder for Councillor Walter's proposal? Okay, in that case, I believe that we will go with the officer's decision. Is that right, Claire? Are we doing okay here?
Yes, Chair, that would be correct. There's just a motion on the table. There's no seconder for Councillor Walters, so that would be the LRB are agreeing with the recommended decision of the officer as set out on pages 74 and 75 of the papers to refuse the planning permission in principle.
Okay, thank you for that. Does that constitute you recording the decision there, Claire?
Yes, I believe the independent planning advisor would like to come in as well.
Thanks, Chair. I think Claire's already covered it. It's just to point out this is a slightly unusual case because there hasn't been a determination by the appointed officer, so there hasn't been a decision. So you are going with the appointed officer's recommendation, as it appears on pages 74 and 75. So this is your own decision. You're making a fresh decision because one hasn't already been made on this case. So it's just to kind of explain that subtle difference. But I'm quite happy that the clerk's covered that.
Yeah, that's a technical point, but one that's obviously worthy of noting and making sure we record it appropriately. Keith, do you want to come back in, please?
So on that point, then, if we make this decision, then what's the next step of appeal for the applicant? Because it's already come to LRB.
Scottish Government, I think.
Thanks, Chair. They will have exhausted the right of appeal. In terms of a delegated decision like this, a decision delegated to the appointed officer of the council, they're entitled to come to the local review body because a decision hasn't been taken in this case. You're now making a decision on this case, and when that goes out, they will only be able to take that to the Court of Session, potentially for judicial review, which is a legal process. In terms of a further planning submission, they could submit a further planning application, and then they could ask for that to be taken to the Council's Planning Applications Committee. Alternatively, they could come back to the local review body if they're not satisfied with the appointed officer's decision or they've not got a decision within the statutory timescale. So at the moment, I would suggest, unless they petition for judicial review, which is quite rare, I think they would possibly want to submit a further application. But that's entirely up to the applicant.
Thanks, Robert. Just to finalise that one then, Claire, if we can record it as make the decision not to approve in line with the officer's recommendations as opposed to upholding the officer's decision.
Yes, certainly, Chair. As set out in pages 74 and 75, you're agreeing with the recommended decision of the appointed officer, and the LRB are refusing the planning permission in principle. Thank you.
Thank you very much. Thanks, members. Okay, moving on to agenda item number 5. Refusal of planning permission for formation of a box dormer extension and for elevation and formation of 2 box dormer extensions on rear elevation of dwelling at 41 Main Street, Glenluce, Newton Stewart. Planning reference 23/1365/FUL. Okay, in line with guidance issued earlier, we'll go through each of the sections. Notice of review dated 5th of February 2024, submitted by CP Designs. The members have any... Sorry,
Chair, would you like
go on, Claire.
Would you like me to take you through the papers as for this item as well, as the usual practice? Thank you.
Yeah. As I say, this is what happens when you give it to an inexperienced chair, but carry on, thanks.
Okay, thank you, Chair. Okay, the papers, we've got the notice of review, report on handling, observations of the appointed officer, planning application form, decision letter, relevant extracts from the LDP2 and National Planning Framework 4, photos of application site and locality. The grounds of refusal are, in this case, the massing, scale and design of the box dormer proposed to the principal southeast elevation of the host dwelling would fail to preserve prepare to preserve or enhance the character and appearance of the host dwelling and its immediate neighbourhood, contrary to National Planning Framework 4, Policy 16, Quality Homes, Dumfries and Galloway Council Local Development Plan 2, Policy H2, Alterations and Extensions to Dwellings and Supplementary Guidance, Alterations and Extensions to Dwellings. The question of method of determination is that the applicant has asked that the review be dealt with by means of a review of the relevant information that's been provided without any further procedures. Grounds stated in the notice of review are in summary. Every planning application should be considered on its own planning merits and should also be transparent throughout the region when making decisions, but clearly this has not been the case. The planning application complies with LDP2 Policy H2, alterations and extensions to dwellings and the related LDP2 supplementary guidance. The case officer has not given consideration to the two-storey buildings either side, nor the fact that 2/3 of the existing roof covering will remain. There were no objections from neighbours or other members of the public. A letter of support for the proposal was received from Old Luce Community Council. Photographs have been provided of the locality. There is a box dormer immediately opposite the application site, which is much greater in size and scale than what is proposed with this application. If all the relevant development plan policies for LDP2, OP1, OP2, ED10, H8 and supplementary guidance, alterations and extensions to dwellings, design quality and placemaking. And for MPF4, it's policies 1, 2, 3, 14 and 16. Main issues for the local review body to consider are: does the proposal fail to comply with the terms of the development plan? In particular, does the proposal fail to accord with LDP2 Policy H8, alterations and extensions to dwellings and associated LDP2 supplementary guidance, also entitled alterations and extensions to dwellings? Would the proposal fail to accord with the terms of MPF4 Policy 16? Specifically, would the proposal be a virtue of the massing scale and design of the box dormers fail to preserve the character and appearance of the host dwelling and its immediate neighbourhood? If it is considered that the proposal does not accord with the terms of the development plan, are there a set of material considerations of sufficient weight to justify a departure from the terms of the development plan? If so, on what grounds would such a decision be made, and what reasons would members give for such a decision if it was considered that the proposal departs from the terms of the development plan? If members are minded to reverse the appointed officer's decision and instead grant planning permission for this proposal, what set of conditions and reasons would members wish to see attached, if any? If members are instead minded to vary the terms of the appointed officer's decision and make reference to the relevant determining policies beyond those stated within the delegated report and decision notice, what changes to the specific reasoning for the decision would be required, and which additional policies, if any, would be referenced? So, again, having outlined your documents, you have the same options available to you as you had outlined for the first item. And again, you have your independent planning advisor present for this case. And again, you have a solicitor present who will act independently as required on the advice of matters of law. So members are clear and no further clarification is required. I'll ask the chair again to lead the debate and in the first instance to lead you through the agenda papers together to decide if you have sufficient information before you to make the determination today.
Thanks, Claire. Get yourself a drink. Okay, members, do we have sufficient information here? Oh, very shy this morning. Councillor Webster.
Yes, Chair, I think we have sufficient information before us to allow us to make a determination today. Thank you.
Thank you. No views to the contrary. Okay, so we'll work our way through the papers, starting on page 159, notice of review. I think that's right, yeah. We've got CP Design who have put their papers in. Any questions or comments by members? No neighbour or public objections, but a letter of support from Glen Luce Council. The response, no mention of a delegated report of the two-storey house either side, nor the fact that 2/3 of the existing roof remain, as Claire already made mention in that initial introduction. Okay, moving on to part 2, report handling. Officer outlines what the current situation is, says there are no consultations to carried out. There is support from the Community Council as mentioned. Under 4.3 on page 177, proposal primarily falls to be assessed against NPF 4, policy 16. Policy 16 on 4.4, proposals will be supported whether they not have a detrimental impact on the character or environmental quality of the homes. 4.5, alteration extensions to dwellings will be supported. So we have under NPF 4 a suggestion that this would be looked upon favourably. However, when we get to 4.6, it does say halfway through there, dormers should be as small as possible, generally located within rear roof slope. Planning authority will resist dormers within the front roof slope unless they are a dominant or original feature of the street. Carrying on, often inappropriate in appearance, and therefore applicants are encouraged to consider a variety of other roof types, etc. So the guidance again, sort of saying that in certain circumstances it would support it, but in other more specific circumstances perhaps not. Turn the page to 178 and 4.9. Applicant was requested to give consideration to amending the proposal, but has decided not to do that. Okay, moving further on, we've got some emails and we've got comment. Again, this is where I picked up about them being in reverse order earlier. Not sure why being so harsh with the application. Maybe the name in the title box sounds like Clark Preston or Preston Clark, I'm not sure which, is raising issues. Old Luce Community Council, yeah, moving on. If we go to page 195, we've got one of the officers corresponding, I think, with a senior colleague. And again, 2/3 of the way through that amendment will almost certainly be resisted, and the refusal will certainly end up at the LRB. Clearly a bit clairvoyant as well. Then we have some drawings, pictures. On to part 3, observation of the appointed officer, applicant's agent and review. It looks like the applicant has submitted this at 1.2 on page 205. No third-party objections. Statement of support from Old Luce Community Council, as mentioned. Proposal will improve living space within the property. Proposal will not have detrimental impact on the street scene. And Glen Luce is not a conservation area. Goes on at 1.3, the reason for refusal relates to matter of design and external appearance only. 1.4, towards the end of that, on the same page, 205, the existence of other unauthorised or historically permitted developments does not provide justification for further similar development. And at 1.5, applicant declined to amend their proposal. Any other comments, colleagues? Oh, sorry, just one on 206 at 1.7. Consider that the case officer's report on handling is accurate, clear and thorough. Okay. Moving on to section 4. Again, I've got some applicant and then some internal and external drawings. No comments, no. Section 5, decision letter from Dumfries and Galloway Council on the 19th of January. Pretty much outlining what was said previously as we've gone through this. Item 6, relevant extracts from Dumfries and Galloway Local Development Plan, which I'm sure Robert will be able to guide us through, should we need to. Robert, can I just ask one question, please? And you'll probably come on to it when you're going through this, but on page 261, it says view of host dwelling from Vineview Crescent looking south to rear of dwelling, but it really doesn't indicate, certainly here, which property that is.
Thanks, Chair. Vineview Crescent is located to, it's kind of directly to the north of this property here, as far as I can remember. It's not shown in any of the plans that you have in front of you, but when I'm looking at this, I'm fairly sure it is, and we can come on to this when I present the slides. I think it is the property on the left-hand side, which is a lower scale to the other one. You can see the one that's got a skylight on it. I believe that may be the property there. But I'm not 100% sure, to be honest.
Okay, because I saw that and I just thought, I can see a load of houses, but I really can't see one that's already got a dormer to the back or whatever. So, yeah. Okay. Robert, can I hand it to you to take us through, please?
Thanks, Chair. Again, these are the pictures that have been provided by the appointed officer, well, the case officer in this case that was dealing with it. So the first one you've got is a view of the host dwelling from Main Street. You can see it's got two small flat roof dormers there at the moment. You can also see the properties on either side are greater in terms of their height and mass. The next slide is a wider view. It's a wider view of the host dwelling on the left-hand side there in the middle ground, looking from Main Street towards, it's actually looking towards the kind of northeast from this view, but again you can see the kind of character of the properties that surround it and their mass as well. The next view is another view of the principal elevation from the Main Street. So the members, you will note in the submission that the issue really is with the proposed box dormer on the principal elevation. So that's this elevation that you're looking at here. There is a proposed change to the rear elevation too, but the basis of the officer's decision simply relates to the impact on this elevation and the surrounding area. And this is a wider view. Again, you see the dwelling house there, and it's from the Main Street looking more towards the southeast. And finally, you have this picture of the host dwelling from Vineview Crescent looking south. Now, when I look at it here, I actually think the property may be the one you see just about the middle of the picture, obscured by that kind of large green shrub. I think.
Yeah, I think you're right, because you can see the yellow chimneys just either side of that tree.
Yes.
And that thing. So perhaps the officer needs some guidance in relation to how to take evidential photos in future, perhaps.
I think the other thing that's important to note as well, and you've referred to this, Chair, is the case officer did seek advice from her team leader, and you can see that in pages 195 to 201 of the papers. So you've got further examples of what you've got in that location as well. The other thing, you've had pictures supplied by the applicant's agent on pages 169 and 170, and he thinks those are key to looking at this case. So certainly there's lots of picture evidence in this location to show you the kind of character of the locality relative to box dormers.
Okay, thanks, Robert. If I can take members to pages 195 onwards, there are a number of photographs, a significant number of photographs showing box dormers. I think some of them are from the same property but from different elevations or different directions. But there clearly is a significant number of dormer properties there. But Robert, a lot of them, it says, with the exception of one appears to have been unauthorised on planning, and the other ones we suspect are so old that they were either considered permissible developments. Is that right?
My understanding of it was many years ago, going back certainly to the 1970s and possibly before that, there were permitted development rights which enabled you to form box dormer type extensions, and as a result they kind of proliferated in certain settlements, particularly where you'd limited roof space to try and make things more livable. So you will know of particular places where there has been a lot of box dormer development, and that's certainly, when you see the pictures, there is a lot of previous box dormer development within Glenluce. Having said that, the policy now is clear on alterations and extensions to dwelling house, and policies and kind of legislation change over time. So something that was once allowed under permitted development rights is now subject to planning regulation, and you've got policies that reflect that.
Thank you for that. Anyone got any questions for Robert? Councillor Howley, Ian?
Thanks, Chair. Robert, I don't know if you can really assist me on this particular issue, but it's just regarding the additional accommodation that this application would provide. Could it be reversed so you had the larger box dom going out the back of the property as opposed to at the front? With the, I know you've not got any internal plans there to demonstrate that, but is that something that the applicant was asked to consider?
Thanks, Chair. Happy to answer that. Firstly, I think yes, in theory, when I look at it, I'm not a builder and I'm not an architect, so I should qualify things by saying that. But when I look at the plans that are in front of you, particularly the proposed elevations on pages 219 and 221, which shows the cross-section on page 221 at the base shows that there would still be a peak in the original roof. Now, in theory, you could make a larger box dormer in the rear elevation, and you could have a smaller box dormer on the front elevation, or no box dormer at all. I think that is feasible in building terms. The thing here is that, as I understand it to be, the rear dormer was considered to be acceptable by the case officer, and the agent was asked if he would be minded to effectively change the proposal such that the front dormer was removed as part of the proposal, and the rear dormer would then have been granted permission because it was found to be acceptable, and he declined to do that. So you can't part approve, part refuse, as you know. So what you're looking at is the original proposal that was submitted because the applicant's agent wasn't minded to change it. So when you look on pages 219 and 221, that's what you've got in front of you today. Appointed officer thinks that's unacceptable, has provided the justification for that, which translated into a decision. But you must make a decision on what you have in front of you today in the papers, Chair.
Thank you, Robert. Councillor Howard, just to refer you to page 197, perhaps a clearer drawing, which is replicated in page 221.
Yep.
Perhaps the stairs are the issue, I don't know.
Yep, ideal, thanks, that helps.
Okay, thank you. Okay, colleagues, any further comments or questions? Okay. I'm personally minded to support the officer in relation to this. I do think that when we look at some of the photographs in the latter pages, yeah, from 259 onwards. Not 259 onwards. Excuse me. Yes, the photos between pages 196 and 201. It's clear that there are a number of dormers, and you can understand why the applicant would suggest that there should be permitted in relation to that. But as Robert's already said, a lot of these are very old standing, predate planning changes, and in compliance with our current guidance and rules, I would recommend that we go with the officer's recommendations. Anyone have a contrary view? Anyone want to support that view? Councillor Dempsey?
Just to make things nice and comfortable, Chairman, I will support your proposal to go with the recommended decision presented to us in page 178. Thank you.
Just for clarification, it's not about comfort, but it's about making sure we make the right decision based on the evidence presented to us. Yes, Jim? Okay. Okay, Claire? Can you capture that, please?
Okay, thank you. Chair, I can confirm that the local review body have agreed to uphold the decision of the appointed officer and refuse for the reasons as set out on page 228 of the papers.
Thanks, Claire. Okay, moving on to our final agenda item. Item number 6, Claire. I've remembered that you need to go through this. So all it takes is repetition.
Okay, thank you, Chair. Before I start, I should say that there's a small error on page 297 of your papers that it should read section 4, planning application form submitted on 7th of December 2023, associated plans and supporting information. Okay, going to what's in the papers for item 6, we have your notice of review, report and handling, observations of the appointed officer, planning application form, decision letter, relevant extracts from LDP2 and National Planning Framework 4, and you have the photos of the application site and locality. Grounds of refusal are the proposed front extension is considered to be unacceptable in design by virtue of being inappropriate in scale and overly large in its forward projection. The proposal is therefore considered to be contrary to NPF 4 policies 14 and 16 and LDP 2 policy H8 and the associated supplementary guidance. First is methods of determination, as it be dealt with a review of the relevant information that's been provided without any further procedures. Grounds stated in the notice of review are in summary. Every planning application should be considered on its own planning merits and should also be transparent throughout the region when making decisions, but clearly this has not been the case. For some reason, the case officer has not given consideration to the location and surrounding area. There were no objections from neighbours or other members of the public. Transport Scotland raised no objection to the proposal. No site visit was undertaken by the case officer. An essential part of any planning application is for a site visit to be undertaken to familiarise oneself with an application site and the surrounding area. This is an extremely harsh decision with no justification based on planning policies, nor did this case officer have any understanding of the local area. An additional location plan was provided, but this was ignored. This application should not be at local review. A large-scale location plan was provided. The plan shows the street scene in the area in which two houses are immediately bound on the A77 footpath, and a further three houses are in close proximity to the A77 footpath. This shows the building line to the rear, and regardless of whether the front or back of the house itself faces the A77, the proposed extension sits back with the proposed extension only projecting 3 metres. You have all the relevant development plan policies for LDP2. You have OP1, OP2, H8 and IN7. Supplementary guidance, you have alterations and extensions to dwellings, design quality and placemaking, flooding and development. For NPF4, you have policies 1, 2, 3, 14, 16 and 22. Main issues for the local review body to consider: does the proposal fail to comply with the terms of the development plan? In particular, does the proposal fail to accord with LDP2 policy H8, alterations and extensions to dwellings and associated LDP2 supplementary guidance, also entitled alterations and extensions to dwellings? Would the proposal fail to accord with the terms of NPF4 policy 16? Would the proposal fail to accord with the terms of NPF4 policy 14? And specifically, would the proposal by virtue of its design be unacceptable as being inappropriate in terms of scale and too large in terms of its projection from the dwelling house? If it's not considered the proposal does not accord with the terms of the development plan, are there a set of material considerations of sufficient weight to justify a departure from the terms of the development plan? If so, on what grounds would such a decision be made, and what reasons would members give for such a decision if it was confirmed that the proposal departs from the terms of the development plan? And if members are minded to reverse the appointed officer's decision and instead grant planning permission for the proposal, what set of conditions and reasons would members wish to see attached, if any? And if members are instead minded to vary the terms of the appointed officer's decision and make reference to the relevant determining development policies beyond those stated within the delegated report and decision notice, what changes the specific reasoning for the decision would be required, and which additional policies, if any, would be referenced? So again, having outlined your papers, it falls to the LRB to determine whether it has sufficient information to consider the review. It's confirmed again, with no representations from any party heard today. The same options available to you as outlined for the first case today, and again you have your independent planning advisor who again has had no involvement in this case, and again you've got your solicitor present who will act independently if required. So the members are clear and no further clarification is required. I'll ask the Chair to lead you through the papers in the first instance to determine whether you have sufficient information to make the determination today.
Thanks for that, Claire. Okay, members, do we have sufficient information in front of us today to make a determination? Councillor Dempster?
There's only one thing I would say, Chair. On page 272, the review procedure, the applicant has accepted that there will be no further procedure required, and yet in page 276, the agent, they ask for a site visit, and it's entirely in our hands, but I would suggest that we have sufficient information before us to make a determination without any further procedures. Thank you.
Agree with that. Thank you, Jim. Okay, if there's no other comments, we'll work our way through the papers. Section 1, Notice of Review, dated the 9th of February. There's page 275. I'm not sure who's made this correction, but erection of single-storey extension to front scored at and then rear underlined. I'm not sure if that's the agent making a point or if it's been an error that's been corrected, so it'd be great to get that. No neighbour or public objections, no date of site visit because none was undertaken, and then bold, just to draw our attention to it at the very bottom there on page 275, extremely harsh decision, no justification based on planning policies, nor did this plan also have any understanding of the local area. An additional location plan was provided but chose to ignore. This application should not be a local review, no confidence, as I've already touched on. On page 276, the second but last paragraph, respectively, well, I think it's respectfully it should be, ask members to please read LDP policy H8 and then some other comments. But that part in particular, if we turn to page 283, that shows you that the officer did, I'm sorry, I'll move on to that. It is referred to by the officer on page 283. Any other comments on section 1? Okay, section 2, report on handling. A couple of questions from me because the applicant, sorry, what's happening, Claire?
Sorry, I believe your independent planning advisor would like to come in.
Okay, yeah, Robert.
Chair, I wasn't sure if you were asking me a question about the document that appears on pages 275 to 276. That came in with the notice of review paper, and that's been submitted by the applicant's agent, just for the avoidance of doubt. So it's a document that's been submitted by that person.
No, thank you for that. No, that's good for that clarification. No, I wasn't asking a question. I thought we'd get to that when we came to your presentation. Okay, but not a problem. Thank you for that. Section 2, report on handling. Bring to your attention the first 1.1, fronting day 75 Kenryan Road with the rear to Lochview Road. Again, we'll need to have a look at that because I think that the applicant is suggesting that Lochview Road is the front of the premise. Page 283, LDP, policy H8, in paragraph 4.5. Talks about sympathetic to scale, and then 4.6 talks about being inappropriately scaled. And moving on. Any other comments on section 2? Section 3, observations of appointed officer. Fairly straightforward. No comments, questions? Section 4, comments of applicant's agent and observations. And some drawings. Maps. Anything else for that from members? No. Section 5, decision letter from Dumfries and Galloway Council, which is fairly self-explanatory. Section 6, relevant extracts from Dumfries Galloway Local Development Plan, National Planning Framework. We're all fully conversant and familiar with. And then section 7, photo of an applicant site and the locality. Okay, if members have no questions or comments, can I pass it to you, Robert?
Thanks, Chair. Happy to go through the pictures of this one. Again, these have been supplied to me by the case officer, and I haven't visited the application site myself. This is a view from the A77, so this is what's considered to be the front of the property, which has the front door, and this is taken from Google Street View. It is, the perspective is a wee bit distorted here, but it gives you the idea of the relationship to the front. Moving now, again, this is from Google Street View. This is a view looking east along the A77, so you can see the neighbouring properties as they appear there. What you might find as a useful reference point is you have a block plan page 311 of your papers, which shows you the kind of layout. So you've got a plan there that will kind of make sense if you look at that. So this is the A77 here, and moving around 180 degrees, this is looking in the opposite direction, so this is looking west. And again, these images are from Google Street View, so it gives you the idea of the pattern of development relative to the frontage there. You'll notice that there's, in this view, there's no vehicle access to each dwelling house cartilage. This is a view from Lochview Road. Now, Lochview Road is to the south of the application site. You can see the vehicle access, and there's a car park there and a garage on the left-hand side. So this is where this property gains vehicular access, and there are a number of these like this in this row. So this is looking north. It's looking towards the opposite elevation to the property that would have the proposed extension. The proposed extension would be on the side facing the A77. And that's a view of what's termed to be the front of the dwelling house. So this is the north elevation facing the A77 with Loch Ryan itself beyond. And this is another view. This is actually a picture that's been taken by the case officer himself. This is looking kind of southeast along the A77, so you can see the existing pattern and style of houses in this direction. You'll also notice the extension to the house immediately next to this one as well. And this is a closer view of the properties further east along the A77, so you can get an idea of what the kind of prevailing character and pattern is. This again, it's a view from what's termed to be the front of the dwelling house looking towards the northeast. And this is a view in the opposite direction, so this is towards the southwest, and you've got Loch Ryan beyond the A77 on the right hand side. This is a view from the garden area of the property itself, and this is looking south, so you can see the adjacent garden areas nearby, and a closer view looking west in this case. Now, the proposed extension would project 4.9 metres from here, and it would be 4.5 metres in width. Your best reference points are probably the location plan on page 305 of your papers. The site plan is on the same page, I'm fairly sure. You've got proposed elevations on page 307, and you've got floor plans and sections on page 309, as well as, like I've mentioned, the block plan you've got on page 311. So this is a view, again, this is showing the south elevation, the opposite elevation to Lochview Road. And that concludes the pictures. Happy to answer any questions.
Thanks, Robert. Do members have any questions? Councillor Walters, Keith?
Just a quick question then. Is there a planning definition for what's the front or the back of the property? Because look, obviously the front, the door is at the front where the extension is going to go, but there's no access. There's no vehicle. There doesn't appear to be any pedestrian access. So does that make a difference as to how you define what's the front and what's the back?
It does. You have to make a judgment call as to what the principal elevation of the property is, and it matters in terms of working out permitted development rights since they changed legislation a number of years ago. So you have to take a view on that. The case officer's view here is the principal elevation faces north, even though you have the access road, if you like, to the property as being on Lochview Road, and that's the address of the property. That's where you gain vehicle access. But because of the fenestration and the arrangement and the front door being to the north of the property, that's been taken to be the principal elevation.
Thanks, Keith. Robert, can I ask, I mean, obviously when this property was originally constructed, probably along with all the others in the line, there would have been planning which would have said which would have been the front and back of the house, I would suggest. Is that something that we could access, or?
Thanks, Chair. I think there may be something in permitted development rights legislation which helps guide planning authorities in terms of what's the front elevation and the rear elevation. That may be in the form of a planning circular, but I would need to look at it. It's been a long time since I've looked at that, but I could take some time just now and look and see what I can find, if that would help you, Chair.
Would that help members, or are we happy to carry on? Take silence as acquiescence. Okay. Sorry, Councillor Dempster, Chair.
No, just going to say, I think we should carry on, Chair, because sometimes the configuration of the property lends the individual to work out what's there and what's the back, probably where the kitchen is and where the car park would be to the rear of the property. I agree with the case officer's assumption on that. But if Robert wants to do some research, that'd be fine with me. But I think we should take it as given that the frontage would face the sea and the rear would be where the services would be taken from, like access and garage access, etc. But that's just my opinion, of course.
No, I appreciate your perspective on that. And if we do look at the maps on page 305, clearly the main access to the property does appear to be the one that is considered as the front, as described by Robert earlier. Going into the hall with sitting room off and the kitchen, etc. at the back. So certainly I'm happy to go with that. Any other members have any thoughts, comments or views in relation to the general application, I mean? Okay. Robert, can you give us a little bit of advice? Because clearly the applicant's agent is making quite a comment in relation to the fact that there's been no site visit. I'm assuming that that's not always required.
Chair, it's not a mandatory requirement when you're assessing a planning application. It is an option. In the majority of cases, the case officer will undertake a site visit, but it's, you know, from the information you can get in Google Street View and the information you have on maps and plans that have been supplied, and also pictures that, you know, you may have had obtained for you by a third party, it's not a terribly complicated case. I think it's quite a well-established residential environment. There's no real amenity issues at stake here. It just really comes down to the form, size, scale of development and how that relates to the existing pattern as far as I'm concerned. So it's a fairly straightforward case. Yes, there are some applications you would want to do at least one site visit, possibly 2 or 3, and there are some applications that don't merit a site visit. I mean, in my view, having had staff look at these kind of things for many years, and myself even going further back beyond that, I don't think in this case a site visit is merited. So I don't think that is really fair criticism, to be honest in this case. I appreciate that the applicant's agent doesn't agree with the decision, and that's fine, but I don't see that the lack of a site visit's been fundamental in this case. Just coming back to the concept of principal elevation, I did find some Scottish Government guidance on householder permitted development rights, and that is from 2021, Circular 1 of 2012, and it introduces various concepts, one of which is the principal elevation. And what it says the term principal elevation is used to identify the front of a dwelling house, fronts in inverted commas. Whilst there are exceptions, most dwelling houses are designed so that the front of the dwelling house faces a road. And then it says, having established the principal elevation, the rear elevation will be the elevation opposite the principal elevation. Side elevations will link the principal and rear elevation. So it says, yeah, the principal elevation is a reference to the elevation of the original dwelling house, which by virtue of its design or setting or both is the principal elevation. And it says, where it is not immediately obvious, a combination of the following factors should be used to identify the principal elevation: location of main door, windows, relationship to road, boundary treatment, architectural ornamentation. And then it says, it's unlikely that any single factor will be decisive. The identification of the principal elevation should not be used to control development. There can only be one principal elevation. It is based on the design of the original dwelling house. So that's basically what you've got. And there are some diagrams in that document too, but as I had thought, it's really down to a matter of interpretation and just kind of, you know, following the logic of it. But in this case, it isn't, you know, the decision has been made relative to this extension of the dwelling house when you look at it as a whole, if you like. So I think in some ways it's a wee bit of a red herring as to whether this is principal elevation or not.
Okay, thank you, Robert. Okay, with all that information, members, are we in a position whereby we can make a judgment on this one? Anyone want to make a recommendation? Okay, in the absence of that, then I'm happy as chair to support the officer's recommendations to refuse planning in this case. Do we have an opposing view? Councillor Dempster?
Just to second your proposal to agree that was recommendation that's out in the papers. Thanks, Chair.
Thank you. Any contrary views? Okay, that being the case, then Claire, can you summarise what we have decided, please?
Okay, thank you, Chair. I can confirm the local review body have agreed to uphold the decision of the appointed officer and refuse the planning application for the same reasons as set out in page 316 of the papers. Thank you.
Thank you very much. And moving on to our last item, any business deemed urgent by the chair due to need for a decision. Nothing's been brought to my attention for today, so can I thank you all for your participation?
Well done, Andy.
Many thanks, Andy. Well done. Thanks for stepping in. You did a good job.
Thanks, Andy.
Okay, folks, I'll
thanks,
catch up with you all soon.